In fact, the leadership with Serbia was so close that the SAO Krajina police was mainly financed with funds and material from Serbia. The support from Serbia continued throughout the indictment period. One witness even described the army of the RSK and the Yugoslav army as one and the same organization, only located at two separate locations. The trial chamber has therefore found that, among others, Blagoj Adzic, Milan Babić, Radmilo Bogdanović, Veljko Kadijević, Radovan Karadzic, Slobodan Milošević, Ratko Mladić, Vojislav Šešelj, Franki Simatović, Jovica Stanisic, and Captain Dragan Vasiljević participated in the furtherance of the common purpose of the joint criminal enterprise. The evidence shows that Milan Martić's contacts with other members of the joint criminal enterprise were close and direct. As a result, substantive financial, logistical, and military support was rendered to the SAO Krajina and the RSK. The evidence is clear that Milan Martić actively worked together with the other participants to achieve the objective of a united Serb state, something which he, as noted, expressed publicly on several occasions. The objective he achieved, this objective he achieved by the forcible removal of the non-Serb population. The evidence establishes that Milan Martić was one of the most important and influential political figures in the SAO Krajina and the RSK governments. As Minister of the Interior, Milan Martić exercised absolute authority over the MUP, including the power to intervene on an individual level by appointing and removing chiefs of public security stations and to disband units. The evidence shows that the displacement of the Croat and other non-Serb population had commenced in and around Knin by 1991. Milan Martić contributed to this displacement by fueling the atmosphere of fear through his media speeches that he could not guarantee the safety of the Croats. Furthermore, the ultimatum issued by Milan Martić in relation to Kiev at the end of August 1991 is indicative of Milan Martić's mindset in relation to the Croat and other non-Serb population of the SAO Krajina. The trial chamber considers that the sheer scale of the widespread and pervasive crimes perpetrated against the non-Serb population must have rendered such crimes common knowledge. Crimes committed within the territory of the RSK were even discussed at RSK government sessions. The evidence also shows that Milan Martić and the MUP were informed by the United Nations civilian police of the multitude of crimes committed against non-Serbs. In fact, Milan Martić himself issued detailed instructions concerning the cooperation of the MUP with the United Nations civilian police. In addition, at a meeting in 1993 with Cedric Thornbury, the UNPROFOR Director of Civil Affairs, Milan Martić requested that Croats who wished to leave the RSK sign statements that no one had put pressure on them to leave. There is therefore absolutely no doubt that Milan Martić was aware that the non-Serb population was being driven out as a result of the coercive atmosphere and widespread acts of violence and intimidation in the SAO Krajina and the RSK. However, despite the overwhelming evidence of crimes committed throughout the SAO Krajina and the RSK territory, the trial chamber was only presented with evidence of a few examples where Milan Martić intervened to punish members of the MUP who had behaved in a criminal manner. The trial chamber cannot but conclude that Milan Martić deliberately refrained from intervening against perpetrators who committed such crimes. The trial chamber has therefore found that Milan Martić intended to forcibly displace the Croat and other non-Serb population from the SAO Krajina and the RSK, and that he actively participated in the furtherance of the common purpose of the joint criminal enterprise to create a unified Serb state by such forcible removal of the Croat and other non-Serb population. The trial chamber has found that the crimes perpetrated against the non-Serb population, with the exception of deportation and forcible transfer, were outside of the common purpose of the joint criminal enterprise. However, the trial chamber recalls that Milan Martić was aware that the non-Serb population was being subjected to widespread and systematic crimes, including murder, unlawful detentions, beatings while detained, and crimes against property following the coercive atmosphere in the SAO Krajina and the RSK. The trial chamber considers that this atmosphere was created and sustained by the actions of Milan Martić and other members of the joint criminal enterprise. The trial chamber has therefore found that these crimes were foreseeable to Milan Martić. Furthermore, the evidence includes only scarce reference to Milan Martić acting to take measures to prevent or punish such crimes. In fact, despite the overwhelming evidence of the scale and gravity of the crimes being committed against the non-Serb population, Milan Martić persisted in pursuing the common purpose of the joint criminal enterprise. Thus, the trial chamber considers it proven beyond reasonable doubt that Milan Martić willingly took the risk that the crimes which have been found to be outside the common purpose might be perpetrated against the non-Serb population. The trial chamber has therefore found that Milan Martić incurs individual criminal responsibility pursuant to Article 7.1 of the statute for counts 3 to 14 and count 1, persecution, insofar as it relates to these counts. The trial chamber now turns to the attacks on Zagreb on the 2nd and 3rd of May 1995, with which Milan Martić is charged under counts 15 to 19. In the early morning hours of the 1st of May 1995, armed forces of Croatia launched a military offensive known as Operation Flash on Western Slavonia in the RSK. Negotiations to find a peaceful settlement took place during the operation, and agreements were eventually reached on the 3rd of May 1995. Operation Flesh ended around the 4th of May 1995, with the RSK losing control over Western Slovenia. As a result, a large part of the Serb population fled Western Slavonia. At 1 p.m. on the 1st of May 1995, Milan Martić, the chief of the main staff of the RSK army, ordered artillery fire on the city of Sisak near Zagreb. The order was given in the presence of Milan Martić, who was by then the president of the RSK, and according to the constitution, led the armed forces in peace and in war. Artillery fire was opened at 5 p.m. that day. On the same day, Milan Martić deployed the M87 Orkan unit from the Knin area to Vojnić, which is located about 50 kilometers south of Zagreb. The unit was to take up positions by 2 p.m. on that day. The trial chamber will describe the characteristics of the M87 Orkan shortly. On the 1st of May 1995, a meeting was held between, among others, Milan Martić as president of the RSK, Milan Martić, and the Prime Minister and ministers of the RSK government. Both peaceful solutions involving negotiations and a surrender of parts of Western Slavonia and non-peaceful solutions were discussed. The evidence shows that Milan Martić and Milan Martić were not in favor of a peaceful solution. In the mid-morning of the 2nd of May 1995, without warning, several Orkan rockets struck locations in Zagreb, including the main square, several shopping streets, a school, the village of Pleso near Zagreb airport, and the airport itself. 5 persons, all civilians, were killed in these attacks, and at least 160 persons were severely injured. Many of these victims still today suffer from these injuries. At midday the following day, 3rd May 1995, Zagreb was again shelled by Orkan rockets. The areas hit were the Croatian National Theatre at Marshal Tito Square, a children's hospital, as well as another square. These attacks claimed 2 lives and injured 54 people. Many of these victims also still suffer from their injuries. There is considerable evidence that Milan Martić had considered attacking Zagreb prior to the 2nd of May 1995. Already in 1992 and 1993, Milan Martić, as Minister of the Interior, considered attacking Zagreb as a response to Croatian attacks on RSK cities. On one occasion, he stated that, and I quote, "It would be better for Judgement and his soldiers not to touch us again, because that would compel us to head forcefully for Zagreb and to turn it into Vukovar," unquote. In June 1993, Milan Martić informed Slobodan Milošević that the P-65 lunar rocket system had been moved to the area of Banija and Kordun in order to carry out possible attacks on Zagreb should RSK towns come under attack. In a meeting on the 24th of October 1994 with Peter Galbraith, the United States ambassador to Croatia, Milan Martić, then president of the RSK, threatened to shell Zagreb, stating in effect that attacking civilian targets in Zagreb and attacking the city itself was a way in which the RSK could respond to a Croatian attack. Ambassador Galbraith informed Milan Martić that attacking Zagreb would be a crime. In February 1995, in a speech to the commanding officers of the RSK army, Milan Martić stated emphatically that, quote, "No one can stop us to fire at Zagreb, Osijek, Vinkovci, Zadar, Karlovac, Split," unquote. On the 3rd of May 1995, that is, on the second day of the attacks on Zagreb, Milan Martić stated, and I quote again, "As a countermeasure to what Tuđman did to you here, we have shelled all their cities. Sisak several times, and Karlovac, Zagreb yesterday and today. This was done for you. Today, an ultimatum followed. If they continue to attack our besieged forces, we will continue to attack Zagreb and destroy their cities." In several media statements, Milan Martić admitted to having ordered the attacks. For instance, in a radio interview on the 5th of May 1995, Milan Martić stated, and I quote once again, "That order was given by me personally as a retaliation to Franjo Tuđman and his staff for the order he had given to commit aggression against the Western Slovenia," close quotation marks. Also, on the 5th of May 1995, in a meeting with the United Nations Special Envoy, Yasushi Akashi, Milan Martić stated, in response to Yasushi Akashi's condemnation of the attacks, that, quote, "Had I not ordered the rocket attacks, they would have continued to bomb our cities," unquote. Milan Martić then proceeded to threaten to resume the attacks if their conditions were not met. Milan Martić spoke of, quote, "massive rocket attacks on Zagreb, which would leave 100,000 people dead," unquote. The trial chamber will now focus on the M87 Orkan. This weapon is a multi-barreled rocket launcher which launches non-guided rockets. The primary use of the M87 Orkan is to target soldiers and armored vehicles. The evidence shows that each rocket launched on Zagreb on the 2nd and 3rd of May 1995 contained a cluster warhead loaded with 288 so-called bomblets. Excuse me. These bomblets are ejected at a height of 1,000 meters above the targeted area. Upon impact, each bomblet explodes and releases 420 steel pellets. The lethal range of each pellet is 10 meters. This means that each rocket releases around 120,000 pellets. The maximum firing range is 50 kilometers, and at this distance, the weapon displays a targeting error of 1 kilometer in any direction. The evidence shows that on the 2nd and the 3rd of May 1995, the M87 Orkan was fired from the Vojnić area near Slavsko Polje, which is at the extreme of the weapon's range. The evidence shows that by virtue of its characteristics and the firing range in this specific instance, the M87 Orkan was incapable of hitting specific targets. For these reasons, the trial chamber has found that the M87 Orkan is an indiscriminate weapon, the use of which in densely populated civilian areas such as Zagreb will result in the infliction of severe casualties. The defense has argued that there were military targets in Zagreb at the time of the attacks on the 2nd and 3rd of May 1995, including the Ministry of the Interior, the Ministry of Defense, Zagreb Airport, and the Presidential Palace. In view of the characteristics of the M87 Orkan, the trial chamber has found that the presence or otherwise of military targets in Zagreb is irrelevant. The defense argument has therefore been dismissed. By the 2nd of May 1995, the effects of firing the M87 Orkan on Zagreb were known to those involved. Moreover, before the decision was made to once again use this weapon on Zagreb on the 3rd of May 1995, the full impact of using such an indiscriminate weapon was known beyond doubt as a result of the extensive media coverage on the 2nd of May 1995 of the effects of the attacks on Zagreb. The defense advances the argument that the attacks on Zagreb were lawful reprisals under customary international law. It argues that the attacks were carried out with the aim of putting an end to violations of international humanitarian law committed by the Croatian military and police forces, particularly during Operation Flash. The defense submits that this operation was a breach of the ceasefire agreement and conducted without respect for the norms of international humanitarian law. In the law of armed conflict, belligerent reprisals are acts which would otherwise be unlawful, but which are rendered lawful by the fact that they are taken in response to a violation of that law committed by another belligerent. As a drastic and exceptional measure, reprisals are subject to strict conditions which are well established in customary law. Reprisals may be used only as a last resort and only when all other means have proven to be ineffective. They may only be undertaken when a prior and formal warning has been given, which has failed to put an end to the violations committed by the adversary. Moreover, the decision to undertake reprisals may only be taken by the highest political or military level. A further requirement is that reprisals must be proportionate to the initial violation of the opposite party. The reprisals must also be seized as soon as they have been achieved. Lastly, acts of reprisal must respect the laws of humanity and dictates of public conscience. The trial chamber interprets this condition to mean that reprisals must be exercised to the extent possible in keeping with the principle of the protection of the civilian population in armed conflict and the general prohibition of targeting civilians. The trial chamber disagrees with the defense and finds that the evidence fails to show that the conditions for lawful reprisals have been met. First, even if the trial chamber were to assume that the Croatian forces had engaged in serious violations of international humanitarian law during Operation Flash, the evidence shows that the shelling was not carried out as a last resort, after all other means had been exhausted. Indeed, the evidence shows that peace negotiations were ongoing during Operation Flash until the 3rd of May 1995. Furthermore, no formal warning was given prior to the attacks that reprisals would be carried out in reaction to the alleged violations conducted during Operation Flash. The trial chamber cannot therefore find that the shelling of Zagreb constituted a lawful reprisal. The defense argument has consequently been dismissed. The trial chamber has found that Milan Martić's responsibility for the attacks on Zagreb on the 2nd and 3rd of May 1995 is most appropriately described as ordering pursuant to Article 7.1 of the statute. Other modes of liability have therefore not been considered. In order to reach this finding, the trial chamber has considered the considerable evidence that Milan Martić, from 1992 onwards, considered attacking Zagreb as a response to Croatian attacks on the RSK. The trial chamber has also considered Milan Martić's repeated admissions in the media that he ordered the attacks, as well as the evidence that Milan Martić and Milan Čelekatić were not in favor of a peaceful solution to Operation Flash. Milan Martić was also present when Milan Čelekatić ordered the shelling of Sisak. The trial chamber considers the totality of the evidence to establish that Milan Martić was involved from the beginning in the RSK's military response to Operation Flash. The trial chamber has considered the evidence that, according to the RSK Constitution, the President led the RSK army in times of peace and war, in accordance with the Constitution and the decisions of the Supreme Defense Council. Accordingly, any decision to shell Zagreb should have been taken by the collegiate body of the Supreme Defense Council. However, the evidence establishes beyond reasonable doubt that Milan Martić and Milan Čelekatić circumvented the Supreme Defense Council. In this regard, the trial chamber has considered the evidence of Rade Rasheta, Chief of Security of the main staff of the RSK Army, that the decisions to attack Zagreb on the 2nd and 3rd of May 1995 were not taken by the Supreme Defense Council, but by Milan Čelekatić and Milan Martić. This is also supported by other evidence before the trial chamber. In light of the totality of the evidence, the trial chamber has found it established beyond a reasonable doubt that Milan Martić ordered the shelling of Zagreb on the 2nd and the 3rd of May 1995. The trial chamber will now turn to the matter of sentencing. Many of the crimes proved in this case were committed with discriminatory intent, and the trial chamber considers that this is a factor to be taken into consideration when assessing the gravity of the criminal conduct of Milan Martić. Milan Martić has also been found guilty of the crimes of deportation and forcible transfer. The trial chamber particularly notes that the non-Serb population was subjected to widespread and systematic crimes as a result of the coercive atmosphere in the SAO Krajina and the RSK between 1991 and 1995. The scale and systematic nature of these crimes are factors which the trial chamber considers to be of particular gravity. The trial chamber recalls that the majority of the crimes for which Milan Martić has been found guilty were committed against elderly people, persons held in detention, and civilians. The special vulnerability of these groups of victims add to the gravity of the crimes. The trial chamber recalls the effects of the crimes committed on victims and their families, and notes that virtually the entire Croat and other non-Serb population was expelled from this area. Many victims had their property looted and burned. The trial chamber recalls in particular the horrific injuries and the serious suffering inflicted on civilians as a consequence of the indiscriminate attacks on Zagreb, which Milan Martić ordered. The impact and long-lasting effects of these crimes, for which Milan Martić is individually criminally responsible, including as a direct perpetrator, render them especially grave. In relation to aggravating circumstances, the trial chamber has considered the fact that Milan Martić was one of the most important and influential political figures. Milan Martić exercised absolute authority over the MUP, and as president of the RSK, Milan Martić held the highest political office and controlled the armed forces of the RSK. The trial chamber considers that in holding such positions, Milan Martić was obligated to prevent the commission of crimes and to ensure that all inhabitants of the territories under his authority enjoyed respect for human rights. However, the evidence presented to the trial chamber proves beyond a reasonable doubt that Milan Martić abused his positions, and that he, through continuous and systematic efforts to create an ethnically Serb territory, promoted an atmosphere of mistrust and fear between Serbs and non-Serbs, in particular Croats. Lastly, the trial chamber considers that the widespread criminal conduct which covered the entire SAO Krajina and RSK territory during a period of more than 4 years serves as an aggravating circumstance. In relation to mitigating circumstances, the trial chamber recalls that during the summer and autumn of 1991, Milan Martić instructed persons involved in humanitarian assistance to treat Croatian Serb refugees arriving from Drniš equally. The trial chamber further recalls Slobodan Milošević's testimony that Milan Martić, quote, demonstrated the nobility of his character, unquote, by looking after refugees who arrived from Bosnia-Herzegovina in 1994, despite the difficulties which the RSK was facing due to international sanctions. However, the trial chamber considers that even though there is evidence showing positive traits in the character of Milan Martić and that sporadic help was given by him to Croats and other non-Serbs, the effect thereof is diminished by the fact that Milan Martić, at all times relevant for the crimes for which he has been found guilty, held positions in which he was able and obliged to take measures to address acts of violence. The trial chamber recalls that in such a case, sporadic benevolent acts or ineffective assistance may be disregarded. Moreover, the trial chamber has considered the fact that Milan Martić and his family were expelled and displaced following Operation Storm to be a mitigating circumstance of limited weight. The trial chamber notes that Milan Martić evaded justice for around 7 years in the knowledge that an indictment was issued against him. The trial chamber therefore finds that the fact that Milan Martić surrendered in 2002 to the tribunal, although constituting a mitigating factor in this case, will be given only minimal weight. The trial chamber has taken account of all relevant legal considerations, the details of which are set forth in the written judgment. Mr. Martić, please rise. This trial chamber, having considered all of the evidence and the arguments of the parties, and based upon the factual and legal findings as determined in the judgment, finds you, Milan Martić, not guilty of count 2, extermination, a crime against humanity. The trial chamber finds you, Milan Martić, guilty pursuant to Article 7.1 of the statute of the following counts. Count 1, persecutions, a crime against humanity. Count 3, murder, a crime against humanity. Count 4, murder, a violation of the laws or customs of war. Count 5, imprisonment, a crime against humanity. Count 6, torture, a crime against humanity. Count 7, inhumane acts, a crime against humanity. Count 8, torture, a violation of the laws or customs of war. Count 9, cruel treatment, a violation of the laws or customs of war. Count 10, deportation, a crime against humanity. Count 11, forcible transfer, a crime against humanity. Count 12, wanton destruction of villages or devastation not justified by military necessity, a violation of the laws or customs of war. Count 13, destruction or willful damage done to institutions dedicated to education or religion, a violation of the laws or customs of war. Count 14, plunder of public or private property, a violation of the laws or customs of war. Count 15, murder, a crime against humanity. Count 17, inhumane acts, a crime against humanity. Count 19, attacks on civilians, a violation of the laws or customs of war. The trial chamber has found that the elements have been established for murder and cruel treatment, respectively, charged under counts 16 and count 18 as violations of the laws or customs of war. As these crimes are absorbed by the crime of attacks on civilians under count 19, the trial chamber has only entered a conviction for the crime of attacks on civilians. The trial chamber sentences you to a single sentence of 35 years of imprisonment. Pursuant to Rule 101C of the rules, you are entitled to credit for time spent in detention, which, as of the date of this judgment, amounts to 1,855 days. You are also entitled to credit for such additional time you may serve pending the determination of any appeal. Pursuant to Rule 103C of the rules, you shall remain in the custody of the tribunal pending finalization of arrangements for your transfer to the state where you shall serve your sentence. The hearing is now adjourned.
All rise. We will wait.